Thank you, Your Honor. We are here in the matter of the State of Ohio versus Haley Gibbs, case number 26CR000520. The defendant is present with her attorney, Nicolette Tomazik. We are set today for a treatment in lieu of conviction hearing. A one-count information was filed in this matter alleging a violation of 2925.11a, aggravated possession of drugs with the attached forfeiture specification, felony of the 5th degree. It's the state's understanding that the defendant will be pleading to this whole count in the attached specification today. Thank you.
Thank you. Ms. Tomazik, would you like to be heard on your motion?
Yes, thank you, Your Honor. We would like to ask the court today to grant the motion for intervention in lieu of conviction. Your Honor, Ms. Gibbs is eligible. This is her first ever felony offense. She has had prior felony reductions. Most of her criminal history does relate to drugs. Your Honor, this case did happen due to drugs, also mental health issues. Ms. Gibbs has been addressing those in the jail. We do have a plan. Ms. Gibbs does have a plan in place for herself. Her intention is to enter and complete the residential treatment at Oak House. She could be transported tomorrow on June 30th at 9 a.m. from Aaron from our office could do the transportation. Your Honor, she also does have a pending misdemeanor out of Mentor Municipal Court. It is her intention to enter and complete the drug court as well. So, Your Honor, we would just like to ask the court to grant the motion due to Ms. Gibbs' treatment that she has lined up. Thank you.
Thank you. Ms. Gibbs, hang on one second. Your lawyer filed for what, on your behalf, it's called a motion for intervention in lieu of conviction. I'm sure she talked to you about that a little bit, explain what that was. But what that is, it's a request to the court that you plead guilty to the charge, but you don't get found guilty of the charge. Instead of being found guilty and being sentenced, instead the court stays or postpones any further criminal proceedings and puts you on a period of supervision with the probation department with certain conditions to follow to address the drug issue that caused you to be here today. And if you successfully complete that program, that period of rehabilitation, the case will get dismissed. You won't have this conviction won't be on your record, and you won't have a felony conviction. So it's a pretty big deal, especially this day and age with the conviction on your record. For all intents and purposes, you meet all the eligibility factors. There's one that needs to be determined by me, and that is that you are willing and able to comply with all conditions set forth by the court and the rules of probation. And here's my concern, to be honest with you. You don't have any felony convictions. But that's not because you haven't been given breaks before in the past. You've been given multiple breaks before in the past. You've been charged with multiple felonies before, and they've been reduced. You've been put on a diversion program in the past, which is what this is, basically. You've had a case, there's one pending in Mentor right now, which was a felony charge, and they reduced it to a misdemeanor. So you've been given multiple breaks, but yet, here we are. And you continue the behavior. So I'm not sure if you really appreciate what those other courts did in the past to save you from having a felony conviction, but now you're here with me asking me to do the same exact thing that those other courts have done before in the past. Why is it that you're going to, this time, be able to follow the rules and do what you're supposed to do?
Well, I've never been sent to a residential treatment center in the past, so actually this would be a new chapter in my life that I would take seriously, because before I never really was able to spread my wings out, I guess. I never was like a baby bird is pushed out of the nest by its mother, so it needs to spread its wings and grow its feathers to get out in life, to be able to adapt to its new behavior and surroundings. So before in the past, I was not able to get that residential, like,
You weren't able to
opportunity.
get it? You certainly could have gotten it. You could have walked into a resident, you could have put yourself there. You don't need to commit felonies to go to get residential treatment. In fact, when this whole thing was started and you met with probation, you didn't want it. You thought 60 days in jail was enough to get you sober and realize I don't ever want to experience this again and I only need outpatient treatment. Maybe 30 days at the most, but I don't need a 90-day program. That's way too much for me.
But then after talking to certain people, I realized that this opportunity isn't given to everybody, and I should be grateful for it. And it was actually really ungrateful for me to be like that, because I do need help, and I was in denial about the way I was thinking before, because I was hurting my family. I was hurting myself. So I think that residential would help me be able to, like,
There's no question about that. And there's no question that's what you need. And there's no question that if you just did outpatient treatment, you'd be back here within a very short period of time. Residential, and that attitude that you're presenting here today, which is good, you got a good fighting chance here. If you up that good attitude and you put forth the effort. So what you said is correct. You were denying this. So you're going to be willing to comply with whatever orders and conditions are put on you for this, even if it's something that you don't disagree with or you think I don't need. And we're not going to be putting orders and conditions on you just for the sake of putting orders and conditions on you. There is a purpose behind them. You may not agree with it. Maybe you will. You may, but there's certainly people that don't agree with everything that we say. We don't do it just to harass someone or give them a hard time or make things difficult. There's a reason and purpose behind it. And you may not appreciate that or recognize that or think it's necessary, but you're going to have to do it still.
Yeah.
You're going to be able to do that?
Yeah.
When you go to the residential facility, there's going to be people there that don't want to be there. Maybe sort of had the attitude that you had initially when this first started, but they're there because the only other option for them was that they were going to prison if they didn't accept that. So they accepted it, but they don't want to be there, and they're going to have a negative. They're going to be negative. They're going to give people a hard time. You need to separate yourself from that and just focus on yourself when you're there. And if there's people like that, which I'm sure there will be, you just need to distance yourself from them. You'll be able to do that.
Yes.
All right. Ms. Johnson, what's the state's position on the motion?
The state's not opposed to the motion or intervention, Your Honor.
Well, I did review the report that was prepared in regards to the court's referral to the defendant to the probation department for the preparation of the report. She is eligible when I consider all the eligibility factors, and I will find her eligible, and it's my intention to grant the motion. Before I can officially grant it, though, you need to plead guilty to the charge. So we're going to do that first. Assuming that goes forward, I will then grant your motion. But before I can accept your guilty plea, I need to make sure you understand everything that this is about, what your rights are that you give up by pleading guilty, any possible penalties you could face if we did get to sentencing. The way intervention works is that you're going to be put on a period of supervision. If you violate, we'll have a hearing to see if you committed a violation. If I find that you did, I would then lift the stay or vacate the stay of criminal proceedings. I'll find you guilty of the felony at that time, and then we'll proceed to sentencing. So I need to make sure you understand what those potential penalties could be if we ever got to there. Hopefully we're not going to do that, but I need to make sure you understand what that could happen if that happened, what those penalties could be if that happened. Do you understand that? All right. So I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Okay. All right. Let's get started then. How old are you?
31.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Yes, I am prescribed a medication, Your Honor.
What prescribed medication would you have taken just in the last couple days?
I am prescribed a gabapentin. I am prescribed a Roboxin. I am prescribed a psych medication called Depakote. I take levothyroxamine for my thyroid, for my hypothyroidism. I'm trying to think of the other one.
It's 4. There more than
I
that.
know, I'm trying to think of the other one. What's it
There's
called?
one more.
Yeah, there's one more.
What's it for?
My anxiety.
Okay, that's fine then. So what I have, these are all medications you would have taken at least within the last couple of days?
Yeah.
So then I added to the form that you previously read, I've not taken any drugs or alcohol in a 48-hour period preceding this hearing, except for gabapentin, Roboxen, Depakote, thyroid medication, and anxiety medication.
Yes.
Is that accurate?
Yes.
Do any of those medications that you've taken in the last couple of days affect your ability to understand or appreciate where you are, or what's going on around you, or negatively impact you in any way?
No, Your Honor.
All right. Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge that you're going to be pleading guilty to?
Yes, Your Honor.
You had a chance to look that over at some point?
Yes, Your Honor.
In that information, you are charged with one count, and what's alleged here and what you're admitting to is on or about April 11th, 2026 in Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance that contained methamphetamine. That's a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the charge also carries with it what we call forfeiture specification, which alleges during the commission of the offense you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that is illegal to possess just by the nature of the property itself, whereas an instrumentality is some type of property that may not be illegal, but it's being used in an illegal manner to facilitate a crime, and you can't possess it for that purpose. Here it's alleged there's the methamphetamine along with some packaging and a glass smoking pipe. Whole purpose of this is that you forfeit any ownership interest you have in that property. It allows the state to properly dispose of it at the end of the case. It doesn't increase any potential penalty you face if we ever proceed to sentencing. You understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
All right, well then, before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up, and you first of all have a right to a trial. And a trial could be to me as, well, let me back up for a second. I forgot the first thing we had to talk about. What I just read to you, that document that has the charges and information, that's a criminal charge brought by the prosecutor without the case having previously been reviewed by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Now, everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can't give up that right if you desire and go forward in the charge brought by the prosecutor in the information. And your attorney has indicated she thinks that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And what I have in front of me is a one-page document called a waiver of indictment, which sets forth what I've just explained to you about the grand jury process. You have a question?
No.
It looked like we...
No.
You have a grand jury process and you want to give up and waive that right. Before I can go further, I need to be assured you understand this document and that you sign it here in court. Now, my understanding is before I walked down here, you had a chance to go over this with your lawyer. Is that correct?
Yes.
Ms. Tomasic, is that accurate? Did you review this with Ms. Gibbs, read it over with her, answer all her questions?
Yes, Your Honor.
Did she indicate an understanding of it to you when you did that?
She did, Your Honor.
Is that correct, Ms. Gibbs?
Yes, Your Honor.
So you understand what the motion states?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
Now, it also appears you signed the document. Did you sign it?
Yes,
Can you
Your
witness
Honor.
that, Ms. Tomasic?
Yes, Your Honor.
And you as well, Ms. Johnson?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's waiver. I'll make this document part of the record. At this point, I'm going to review with you all the other rights you have. And again, as I started to say before, you have a right to a trial. And a trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and the jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Having the burden of proof means it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charge, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, in order to, if we did have a trial to overcome that presumption, the state would bring witnesses into the court to testify for the state by answering questions from the witnesses. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So she could ask me anything she wanted to, but within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not obligated to do that, but you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order we call a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. You understand that?
Yes, Your Honor.
You realize you're giving up that right too?
Yes, Your Honor.
Now, you also have a right at a trial. You can choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But more importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we went to trial and you were found guilty of these charges, you'd have the right to appeal or challenge that guilty finding to another court that sits above me and reviews my decisions. Now, you're not pleading guilty here today, so you're not going to be found guilty. But if you ever violated the conditions of the plan, as I was explaining before, and you're ultimately found guilty, you're waiving any right to challenge that guilty finding at that point. You could challenge and appeal the reason for the violation if you thought there was an error there in me finding that you violated. But anything leading up to this point that you could have raised as an issue or challenged, whether it's based on the police officer's conduct at the time or anything that I'm doing now, you're waiving your right to appeal any or challenge any of those issues. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you'll be giving up by pleading guilty here today.
No, Your
You
Honor.
understand them all?
Yes.
And you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. So you're admitting to the facts being alleged. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty. Well, no, you won't be found guilty by the court. You're normally found guilty by the court. what normally happens is you're found guilty and then you're sentenced. But as I explained, that's not going to happen here today. But what I do want to do at this point is explain the potential penalties that could happen at sentencing if we ever get to that point, as I explained earlier. And if you ever did violate and you were found and your intervention in lieu was revoked and you were found guilty, we proceed to sentencing. And at sentencing, you could be sent to prison for between 6 to 12 months. That's what this offense is punishable by. Do you understand that?
Yes, Your Honor.
So the maximum penalty is 12 months in prison. I believe I know the answers to these questions, but I'll ask anyway. You're not on probation right now to any of the courts or agencies, are you?
No, Your Honor.
You have a charge pending in Mentor Municipal Court, but that's just a misdemeanor, right?
Yes, Your Honor.
Any other charges pending anywhere else?
No, Your Honor.
Now, if a prison sentence were imposed at sentencing, first off, it could be run consecutive to any other prison sentence you could be serving at that time if something else were to happen after this. Consecutive means one after the other. You'd serve the prison term on one case, finish it, then serve it on this case. You understand the difference there?
Yes.
It could also be concurrent, which means you'd serve them at the same time. You understand that?
Yes, Your Honor.
Same thing as if you had another case pending before me at that time, we were sentencing you at that time, I could do that concurrent or consecutive to that new case at that point as well. Do you understand that?
Yes, Your Honor.
Now, if a prison sentence is ever imposed in this case at any point upon your release from prison, you could be placed on what's called post-release control, sometimes referred to as parole or PRC. It's a period of supervision you'd be on after you completed the prison sentence, and it could be for up to 2 years. You understand that?
Yes, Your Honor.
And if you were on post-release control at any point and you were violating any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. I'll strike that. I'm sorry. If you were on post-release control and you were violating any of the conditions of your post-release control, the parole authority would have a hearing. If they determined that you did violate your PRC, they could send you back. They could send you to prison and return you to prison for up to 9 months. For each separate violation you commit, up to an overall maximum of 50% or half of whatever the term was imposed by the court. Do you understand that?
Yes, Your Honor.
Right. Now, aside from this possible prison sentence that could be imposed if we've ever proceeded to sentencing, there's other sanctions that can be imposed, and some that will. You will be ordered to pay court costs and reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
You will also be ordered to forfeit the contraband that I reviewed with you earlier that was seized as evidence in this case. Do you understand that?
Yes, Your Honor.
Now, if we ever did proceed to sentencing, I could also at that time impose a fine of up to $2,500, and I could also suspend your driver's license up to 5 years. Do you understand that?
Yes, Your Honor.
Now, if prison is not mandatory at that point, you would be eligible to be put on probation if I felt that was warranted. Though it's not automatic, or you're not automatically entitled to that, but it's something I would have to look at and see, look at all the circumstances in particular, why we're back here, what happened to cause you to violate, and make the thing to do. Do you understand that?
Yes, Your Honor.
Now, if you were on probation, it could be for up to 5 years, and as a judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. Conditions could be an order that you serve time in the county jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, Your Honor.
If you're on probation, you violated any of the conditions of your probation, we'd have a hearing to see if you're a probation violator. If it was determined that you were, I could extend your probation up to 5 years, I could impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison then. Again, that could be 6 to 12 months in prison, which could be the sentence you're serving at that time or that you're being sentenced to. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all about the potential penalties you could face if we ever did have to proceed to the sentencing hearing?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about all this with your lawyer and have her review everything with you and answer all your questions?
Yes, Your Honor.
Are you satisfied with her advice and counsel?
Yes, Your Honor.
Has she or anyone else made any promises about sentencing which is inducing you to plead guilty? I'll repeat that. Has she, well, we're not proceeding to sentencing, I guess. I've promised you that I'm going to grant this motion. If you violated, have you been promised what's going to happen in that regard?
Yes, Your Honor.
No.
Oh, no. No, Your Honor.
No, I wanted to make sure. I probably shouldn't. This question is more appropriate in the when someone pleads, they can't be promised that anything that's going to happen to them at sentencing.
Okay.
Now, in this case, it's different because I've told you I'm going to grant this motion
Okay.
of intervention in lieu. That's not really sentencing, though.
Okay.
Sentencing would occur if you violated, and then we had to come back here. And so, in that regard, nobody's told you that if you violate, you're going to still stay on probation or anything like that, have they?
No,
Have you been threatened or coerced in any way to plead guilty?
no,
Are you entering a guilty plea freely and voluntarily here?
yes,
All right.
Your Honor.
Any questions for me at this time, Ms. Gibbs, regarding anything we've just talked about?
No, Your Honor.
Do you need any more time to talk to Ms. Tomasic regarding, or any questions for her? You can talk to her confidentially if you want as well.
No, no, Your Honor.
All right, then what's going to happen at this point, Ms. Johnson's going to advise me of what the facts would show in this case if we had a trial. I want you to listen there because I have some follow-up questions for you about that, all right? Ms. Johnson?
Thank you, Your Honor. Had the matter proceeded to trial, the state would have shown that on or about the 11th day of April 2026 in Lake County, Ohio, the Willowick Police Department encountered the defendant who at the time had a warrant for her arrest. A search of the defendant's purse was conducted. It did reveal suspected methamphetamine. That methamphetamine was seized. It was sent to the Lake County Crime Lab for testing, confirmed to be methamphetamine less than the bulk amount. Thank you.
Thank you. So Ms. Gibbs, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts if she presented them? Are they true? Did you do what she said? Did you knowingly possess methamphetamine on that date?
Yeah, I forgot it was in my purse, but yes.
Well, if you forgot it was in your purse and you didn't knowingly possess it. Now, to be guilty, the state has to prove that.
Yeah, I knew it, yes.
Very well. Regarding count one, charging with aggravated possession of drugs, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty.
All right, I have in my possession at this
Okay.
time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in open court. Now, my understanding is before I walked out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Tomasic, is that accurate? Did you read this over with Ms. Gibbs, review it with her, answer her questions?
Yes, Your Honor.
Did she indicate an understanding of it to you?
Yes, she did, Your Honor.
Is that correct, Ms. Gibbs?
Yes, Your
Do you
Honor.
understand what it says?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
Also appears you signed it. Did you sign it?
Yes, I did.
You witnessed that, Mrs. Tomasic?
Yes, Your Honor.
Ms. Johnson, you as well?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea to count one, aggravated possession of drugs, felony to 5th degree, in violation of 292511 of the revised code, the forfeiture specification. I will, at this time, find the defendant eligible, grant the defendant's motion for intervention in lieu of conviction. I'll order that all further criminal proceedings in this matter be stayed. And I'll place the defendant under the supervision of the Lake County Adult Probation Department for a period of 2 years. And I'm going to order the implementation of the following intervention plan. So my understanding, the defendant has 80 days jail credit, is that right?
That's correct.
Yes, Your Honor.
All right, well, I'm going to sentence her then to 81 days in jail. She has 80 days of credit. What time is she, you have it set up for tomorrow?
9 a.m., Your Honor.
She will be ordered to be released tomorrow on June 30th at 9 a.m. to a representative from the Public Defender's Office. At that point, she will be transported, it's Oak House, right? Not in the Bay, it's Oak House.
Correct, Your Honor. Oak House.
She'll be transported to Oak House, and where you are ordered to enter and successfully complete the treatment program at Oak House. Follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. And that includes no marijuana either.
Okay.
Submit random urine screens. Those have to be negative. Positive screens a violation. You're not to tamper with the urine samples, bring in fake urine, someone else's urine, anything like that. That's actually worse to me than testing positive. You attend 3 AA meetings a week and have a sponsor.
Okay.
Obtain and maintain full-time employment or education. If you want to go to school and get some type of training, certification, anything, you can do that as well. But on a full-time basis, you need to be keeping yourself busy, either working, going to school, or some combination of the two. You understand
Okay.
that?
Yes, yes, Your Honor.
You're to have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine as well also. But only those doctors that you advise probation about can give you prescriptions for medication. If you get a prescription from some other doctor that they're not aware of, then that's a violation. You look like you have a question about that.
I go to Signature Health, so they give me a psychiatrist and a primary care doctor.
That's fine, as long
Okay.
as you tell probation who those doctors are that are giving you prescriptions.
Okay,
You need to tell them who the doctors are that you get prescriptions from.
okay,
And you can't get prescriptions from anyone else other than that,
that's fine.
okay? And you can only go to one pharmacy where you get them filled. They need to know where that is.
Okay,
Right. And you sign whatever releases they need so that if they need to contact any of those doctors or counselors, they're able to do that.
okay,
I want you to obtain a mental health evaluation and follow whatever recommendations are made for any type of counseling or treatment in that regard. It sounds like you're hooked up with Signature Health now, so continue following those recommendations and take all medications as prescribed.
okay,
You pay your court costs and supervision fees. You're not to have any contact with Christopher Bartunek. You understand that?
okay,
That I don't know if I pronounced it right. Bartunek, yeah. No contact with him. When I say no contact, that's in any fashion, not just face-to-face, but you can't email him, text him, call him on the phone. You can't have someone else reach out to him and contact him for you. You understand that?
yes, Your Honor.
Derek, anything else I should think about for this plan?
No, Your Honor, thank you.
So Ms. Gibbs, you understand all the conditions of the intervention plan I just imposed?
Yes, Your Honor.
Any questions for me?
No.
Now, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit a new offense going forward, and I'm not talking about this Menor case, I know that's already pending, so you resolve that, however it gets resolved, it's not going to impact this, but if you get a new case from this date forward, new charges for new conduct that you can engage in after this date. If anything like that happens, a motion to terminate your intervention in lieu of conviction will be filed. If it's found that you did violate after a hearing, I will terminate the intervention in lieu of conviction. I'll lift the stay of criminal proceedings. I'll find you guilty of this charge and we'll proceed to sentencing where any of the penalties that I just explained to you a few moments ago could be imposed. You understand that? Which includes up to 12 months in prison. You understand that?
Yes, Your Honor.
All right. Ms. Johnson, is there anything else for the record?
Nothing from the state, Your Honor. Thank you.
Ms. Tomasic?
No, Your Honor, thank
All
you.
right. All right, Mr. Clammer, would you like to be heard on your request?
Yes, Judge, thank you. We did file the prior motion at that time. Really, at that point in time, the only things I could really rely on were his successes prior to incarceration. I was reminding the court of all the things he had done, graduating nearly a 4.0, 3.7, 3.8 from high school, some college, moving off to industry, and then owning his own businesses. He was having a great amount of successes before we found him here. He was the reason, in large part, they discovered the cocaine in his premises because he cooperated with the officers and turned it over. We talked a lot at that time, Judge, about the various griefs he'd had over the last 5-6 years of his life, which I think was the best explanation we could find for how he found cocaine as a problem, because by all accounts it seemed to be something he came to later in life. At that time, Judge, you did deny it, and to a certain degree that was fortunate because he's had an opportunity to then prove to that he participated in all these other programs. We talked a little bit in chambers, but just for the record, he's had some 330 hours of community service time. Much of that community service time is related to him tutoring inmates to get their GED in the library. In the prior motion, I referenced how he's been working in the library pretty much. That was his go-to service obligations while he was there. He's since not only tutored those people, he finished his IOP, which is kind of a typical 8-week IOP. He's completed the grief program, which we think has addressed some of the things that he was suffering from before, which he really never sought any treatment for. And he's acquired his CDL, and he's been working these 12-hour shifts that they break up between 3 or 4 drivers outside of the institution for, I think he does almost a full-time 5-day-a-week program. So they've trusted his recovery, and they've trusted him with that type of equipment and getting a CDL. By all accounts, I think he's a great candidate. He is at the stage of being released over to a halfway house. So it's kind of awkward timing-wise, but I think it makes most sense to save, obviously, prison time, NeoCap time, and halfway house time or services for inmates that probably could use it better. I think we should preserve those resources for those types of inmates. I think before this, you would have known him to be an accomplished young man, an accomplished fella, and I think he's going to be that again for you, Judge. In my talking with him, he's indicated what hit him most was, like I told you in chambers, just losing his freedom. And fortunately, I guess that's what the system is supposed to do, but he's the first client I've had in 27 years who said, yeah, that's what struck him most. So he's here with some family. He's here to answer any questions you have, but we'd like you to give him a chance to be released, Your Honor.
Thank you. Mr. Peters, you have the right to address this court at this time. Is there anything you'd like to say at this time in support of your motion?
Stand up. Just tell him.
No, I mean, I just got on a straight path and did what I needed to do to make things better. So, I mean,
Tell him about the impact of losing your freedom. You're the first
Oh,
person.
yeah, absolutely. I mean, losing your freedom is something that I haven't experienced in 40 years. So when you have somebody watching you sleep, you know, someone can potentially see you use the restroom or take a shower, or, you know, just you losing your freedom all in general, it's something that I won't forget personally. Even, you know, the random checks when you have to strip or, you know, strip searched, or even watching them tear your area up and throw things in the middle. It's just one of those things that I never thought I would experience. And yeah, it's I won't be doing that again.
What are your plans if I were to grant this motion? What are your thoughts in terms of what you're going to do?
I've been applying for jobs, so since I got my CDL, a company reached out to me, LoadLink Logistics. They asked me if I want to work with them out of Macedonia, Ohio. So I didn't know how this is going to go, so I just told them I'd get back to them. But I am looking to work in the logistics industry and drive the truck. I got my CDL, so I can drive triples, doubles, tankers.
How do you get that in prison?
It's a program that the state of Ohio offers. So basically, it's a 12-week program, and then what we do is we drive for the prison. So I had outside clearance to drive from Grafton, Ohio.
Actually, that's my question. I mean, you can't just get it in books. You got to show that you
Driving.
have
Well, you have
driving ability.
Well, you have to, in order to get in that program, you have to fall within a range of your recidivism and your security level. So once they do an assessment on you there, then they say, okay, you qualify for the program. And then with me, they gave me I was able to drive from Grafton to Richland, Ohio, Monday through Friday, without the corrections officer. Which is just a contractor there in the truck with 4 of us. And it's actually kind of cool. You don't know that they're there, but it's inmates that drive these trucks back and forth every day. They even have porta potties for us to stop that's specifically for us. And yeah, I would have never knew that those were inmates driving until I participated in that program.
So that's what you're trying to get into now then?
Correct.
Where are you planning on living?
Right now, I got a place in Mentor, or East Lake is where the apartment is with a friend that I'm gonna.
So you're going to be moving in with a friend?
Correct.
Is a friend and they don't have any issues?
No issues.
No drug or alcohol issues?
No, drug-free environment.
Who is it?
Jessica Duca and her husband.
Duca?
Yeah.
I think I did have an email or letter from her in my motion, Judge. I just didn't have it printed with me.
Anything else you'd like to say, Mr. Peters? Tell me about what's the drug and alcohol treatment counseling you received when you were in prison?
So when I was in prison, with me doing the tutoring, my case manager, she came to me and she was interested in me being a peer support. So in order to be a peer support inmate, you have to do your IOPs. So basically they had me do the Thinking for a Change, Decision Points, the cognitive thinking programs. Then I had to do career enhancement programs. So I would be more so like a liaison for the inmate to come and get information as to what programs they could get in to better themselves.
But I wonder what you, in terms of what did you receive treatment-wise or counseling?
Oh, I did the Thinking for a Change, the Decision Points, Money Smart, Credit.
What about in terms of drugs or alcohol counseling treatment?
It's recovery based. So they had us doing. It's a program called Recovery Bay. It's you have to go to AAs, NAs, meditations. It's a long list of things you have to complete. I can't remember everything because it's so detailed, but you have to complete it, and every round it increases. So I went through all 3 rounds of the Recovery Bay.
Approximately when was that? At the best of your ability.
I started in August, and I completed it when she sent the letter. So.
Yeah, I'm sorry, I didn't bring it with me, Judge.
That's all right.
Yeah, my case manager sent the letter, but it was completed in roughly February.
Okay, so about 6 months.
Correct.
All right, anything else you'd like to say?
No, sir.
Mr. Clammer, anything else on behalf of Mr. Peters?
No, Judge, thank you.
For the State of Ohio, Ms. Contour?
Thank you, Your Honor. As I stated in chambers, the state is objecting to the motion for judicial release. Just to review some of the facts that were the basis of this case, counts 4, 5, and 6 were all from controlled buys that were done for the LCNA with the defendant, and then there was a warrant served on his home. There was drugs found in his vehicle completely throughout his home, scales in the kitchen. There was multiple firearms which he forfeited. There was also $4,000 worth of cash in his office drawer that had money from the controlled buy. So we were able to tie that back to that. And so it indicated to us that he was running this as a business, and there was a larger issue than he was letting on at the time of sentencing. It was found at the time of sentencing that the benefit was given to the defendant in the plea offer. The reason that that was done is because of his honesty. Count 1 was a felony of the first degree amount of cocaine. We did allow him to plead to that F3 by way of information because he was honest that that was in his home, but he received the benefit at that time. The state did recommend prison at that time and still feels that the sentence given was appropriate.
Thank you. Well, this court has considered the original pre-sentence report and investigation, that drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offenses. I have considered the motion that was filed. I've considered everything that's been said here today by Mr. Clammer, the defendant himself, prosecutor's position. All this is considered in light of the purposes and principles of felony sentencing. Considering all the foregoing, obviously when you look at the PSR, the defendant doesn't have any criminal history, but the conduct he engaged in was extremely serious, and he did get a very good break and benefit with the offer that was made available by the state of Ohio. And that offer allowed the defendant to be eligible for probation and community control sanctions. And I know that's what the request was for the time of sentencing, but I didn't believe that was appropriate, and I didn't believe it was appropriate to release him earlier. I think the defendant needed to, this court's view, show that he was serious about all this, and at least prove that to the court, instead of just by his words. But he did that, at least in this court's view he did. So I find the motion is well taken. I'm going to grant the motion for judicial release. I'm going to place the defendant on community control sanctions for a period of 2 years. I'm going to order that he serve 5 additional days in jail to be released on this Friday, July, was it 3rd, I think?
3rd.
July 3rd. Put the specific date in there just in case their 5 days is different from our 5 days.
Yes, Your Honor.
And I'm going to order the following conditions. In addition to the 5 days, that's a condition, obviously. You're not to use any drugs or alcohol. That includes no marijuana. It's to submit random urine screens whenever requested. They all have to be negative. Positive screens a violation. You're not to screw around with or tamper with the urine sample, bring in someone else's urine or fake urine, anything like that. You're to attend 2 AA meetings a week and have a sponsor. To obtain and maintain full-time employment. I want you to obtain a drug and alcohol evaluation as soon as you get out, and follow whatever, if any, recommendations are made for any type of counseling or, treatment. If they say nothing else is needed, fine. If they say you need to do an IOP, then you need to do whatever the recommendations are. I also want you to get a mental health evaluation. I know that was a big issue back at the time. You indicated about the grief counseling that you attended, but I wanted a mental health evaluation. And again, follow whatever recommendations, if any, are made for any type of counseling or treatment. Take whatever medications, if any, as prescribed. I'm going to order that you perform 50 hours of community service. Hey, Cindy, can I see you for 1 second?
Yes.
Mr. Peters, you indicated, I think it was mentioned a couple times, or at least once, about decision points, that you completed that program?
Yes.
When did you complete it? Because the report that we received, which was dated June 2nd, indicates that you were waitlisted just on April 28th. So you hadn't started it as of that time.
No, when I got to Richland, I don't know if if it says when I got to Richland, when I got the original, my case manager put me in it because Grafton didn't offer it. So I was taking decision points simultaneously with the CDL program because it was only on Monday mornings.
This said on April 28th you were waitlisted on it.
Initially, when I first got there, I was waitlisted on it, but he did put me in because I was one of his CDL.
I just don't know how you could have finished it in that period of time. Do you have something that shows that you finished this?
Not with me, but
No,
it's
not
only,
with, I don't mean with you, but.
it's only a 4-week program. So I was there from April 20, whatever day that is, to when did I leave? To when I just left.
When did we bring you back here? A couple weeks ago?
Yeah. So it's only a 4-week program, 4 Mondays, and I ran it simultaneously with the CDL.
Well, I'm going to have you do our decision points program.
Okay.
Do you want to put in there if I can show her proof that we can eliminate that, just to save that resource for somebody else?
No.
Okay.
I mean, he's doing it in only 4 weeks and it's with another program. I think ours is better, to be honest with you.
Yeah, it is what it is.
But I'll tell you what I'll do. It's not a big deal, but I'm going to make it 40 hours of community service. All right, pay your court costs and supervision fees. You need to pay the fine that was previously imposed. Ms. Henley, anything else you think about?
I don't believe so.
No,
Oh,
I see
sorry.
Ms. Henley.
I keep getting Henley and Emily mixed up today.
Oh.
There you go, thank you.
So, Mr. Peters, you understand all the conditions of your judicial release?
Yes, sir.
You have any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, which they'll go over with you before you get out, if you leave Ohio without permission from the court, what does your CDL involve in terms of work?
Well, right now I'm not sure what.
Oh, you don't have the job yet.
Yeah.
When that happens, talk to probation,
Okay.
You mean as far as travel
Yeah.
related stuff? Yeah.
because you're not allowed to leave Ohio without permission from the court. If it's work-related, I most likely am going to allow you to do it, but you're going to need to let them know when you're making these trips
Okay.
and what it entails. But at this point, if you leave Ohio without permission from the court or probation, or if you commit any new offenses going forward, a motion to terminate your judicial release and community control will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and judicial release and send you back to prison. I specifically, at this point, hereby reserve the right to reimpose the balance of the sentence that you were just released from. So whatever is left would be reimposed, and that could be consecutive to any other sentence that you may be serving at that time for something else from another court, or that you're being sentenced to by me at that time for something new if something happened. You understand that?
Yes.
All right. Now your turn. Ms. Contour, anything else for the
Nothing
record?
further, thank you.
Mr. Clammer, anything else?
Judge, thank you.
All right. Cindy, this is your
Santos, case number 24CR93. The defendant is present with counsel Justin Weatherly. A 30-count indictment was filed in this case on February 2nd, 2024. It is the state's understanding that today the defendant will be pleading guilty to the 27 felony counts contained within this indictment. That includes all counts except for 3, 5, and 28. Count 1 is engaging in a pattern of corrupt activity, a felony of the second degree in violation of Revised Code Section 2923.32A1. Count 2 is theft, a felony of the fifth degree in violation of Revised Code Section 2913.02A1. Counts 4, 6 through 27, and 29.
Not count 5?
Not count 5, Your Honor. 4, 6 through 27, and 29 are receiving stolen property, felonies of the fifth degree in violation of Revised Code Section 2913.51A, and count 30 is possession of criminal tools, a felony of the fifth degree in violation of Revised Code Section 2923.24. Upon a plea of guilty to each of these counts, the state and defendant have a joint recommendation of 6 years concurrent to the sentence the defendant is serving in his Florida case.
Thank you. Mr. Weatherly, does that sound accurate?
It does, Your Honor.
Give me 1 second, please. You can be seated. So how many counts altogether?
27, all counts except 3, 5, and 28.
Just checking the math and everything, making sure everything's right. Looks good to me. All right. Mr. Santos, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, sir.
They indicated to the court they believe it's your desire to withdraw your previous entered pleas of not guilty and plead guilty to multiple counts of this indictment. I'll go over those with you. The other 3 counts that you're not pleading guilty to would be dismissed. We would then proceed to sentencing, where there's a joint recommendation being presented to the court that in prison term, it's an indefinite prison term, where the minimum is 6 years, correct?
Yes, Your
6
Honor.
years be imposed. You understand that?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
I'm 33, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here, this morning, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours? medication, nothing?
No, sir.
Now, you would have been served with and received a copy of this indictment previously. It would have been back, let me get that up here. Back around February of 2024, so it was some time ago. But do you remember getting the document that sets forth all the charges?
Yes, sir.
And at some point you had a chance to look that over?
Yes, sir.
Now, in that indictment, you are charged, as referenced here, with 30 counts. You're pleading guilty to 27 of those. I'm going to review, I'm not going to go over individually, I'm going to review the actual charges so, to make sure you understand them. If you have any questions, make sure you ask.
Yes, sir.
But in count one, what is alleged here and what you'll be admitting to is on or about December 20th, 2023 in Willoughby Lake County, Ohio, that you, being employed by or associated with an enterprise, that you conducted or participated in, directly or indirectly, the affairs of that enterprise through a pattern of corrupt activity. The predicate acts constituting the pattern of corrupt activity of this enterprise include, but are not limited to, criminal violations of the offense of theft, as set forth in count one, receiving stolen property, as set forth in count 4 and counts 6 through 27, as well as count 29 and count 30. No, just the 29. So those 25 counts set forth the predicate acts of the enterprise. That conduct constitutes the offense of engaging in a pattern of corrupt activity. It's a felony of the second degree. Do you understand what you're charged with and pleading guilty to in regards to count one?
Yes, sir.
Any questions for me about it?
No, sir.
Now, in count two, what's alleged here and what you're pleading guilty to is on or about December 20th, 2023 in Willoughby Lake County, Ohio, that you did with purpose to deprive Isabel Wright, who was the owner of property, that being a Cardinal Credit Union Visa debit card, a Navy Federal Credit Union Visa card, and a Key Bank debit MasterCard, that you knowingly obtained or exerted control over that property without the consent of the owner, Isabel Wright, or anyone else authorized to give consent. It's further alleged the property involved is a credit card, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count two?
Yes, sir.
Any questions for me about that?
No, sir.
Now, in count 4 and in counts 6 through 27 and in count 29, you're charged with the offense of receiving stolen property. And what is alleged here is that on, are they all December 20th?
Yes, Your Honor.
On December 20th, 2023 in Willoughby Lake County, Ohio, that you did receive, retain, or dispose of certain property, being either credit cards and or blank checks, and that you knew that this property had been obtained through the commission of a theft offense, or that you had reasonable cause to believe the property had been obtained through the commission of a theft offense. And again, the property involved is either a credit card or it is a check that on its face identifies the drawer or maker for whose use it was designed, or identifies the account on which it was to be drawn, and had not been executed by the drawer or the maker, or the amount is blank. So that conduct for each of those counts constitutes the offense of receiving stolen property, and because the property involved is either a credit card or a check, it's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in each of those counts?
Yes, sir.
Any questions for me about that?
No, sir.
Now, lastly, in count 30, what is alleged here is on or about that same day, December 20th, 2023, and here in Willoughby Lake County, Ohio, that you did possess or have in your control any substance, device, instrument, or article, specifically a window punch, and you possessed it with the purpose to use it criminally. The circumstances indicated that this criminal punch was intended to be used for the commission of a felony, which makes the offense possessing criminal tools a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about that?
No, sir.
Well, then, before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to have a trial in this case. And that trial could be to me as a judge, where I listen to all the evidence and I make the decision whether you're guilty or not guilty. but you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. Unanimous means that all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty of each specific charge. You understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our criminal justice system, our entire judicial system, actually. And what that means, it's the amount of the evidence and the quality of all that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to make the state of Ohio prove you guilty beyond a reasonable doubt of a trial?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses to the courtroom to testify for the state, and they'd be answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That is called cross-examination. He would be able to ask him anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have the right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. And what a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she would not be allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we went to trial and you were found guilty, you'd have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that I will enter if your plea is accepted, as well as any other issues that you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt, so it means you're going to be admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, in count one is what we call a qualifying offense. That simply means it's a felony of the first or second degree that was committed after March of 2019. And what happened in March of 2019 is that all felonies of the first or second degree are subject to indefinite sentencing. And when I say indefinite sentencing, that means there'll be a minimum sentence imposed as well as a maximum sentence. In count one, it's a felony of the second degree, so it is a qualifying offense, and that means the court will impose an indefinite prison term with a minimum sentence of anywhere between 2 to 8 years. So I'd select one of those numbers, 2, 3, 4, 5, 6, 7, or 8, and that'd be the minimum sentence you have to serve. The maximum sentence is then determined from a simple mathematical formula. You take half of whatever the minimum sentence is, you add it to the minimum, and that becomes your maximum. So for example, if I imposed the minimum sentence of 2 years, that'd be the minimum. You take half of 2, which is 1, you add that to the 2, it becomes 3, so your maximum is 3 years. So it'd be an indefinite term of 2 to 3 years. You understand that?
Yes, sir.
Another example then, if I impose the minimum sentence of 6 years, half of 6 is 3. You take the 3, add it to the 6, that's 9, so your maximum is 9. So your sentence would be an indefinite term of 6 to 9 years.
Okay.
For the maximum, I need to make sure you understand what the maximum sentence could be. If I impose the minimum sentence in the 8 years as the minimum, which is the most I could impose as the minimum, half of that is 4. You'd add that to the 8. Your maximum then is 12 years, so it would be an indefinite prison term of 8 to 12 years. You understand that?
Yes, sir.
And that's the maximum sentence that you can be served on count one. Any questions about that?
No, sir.
Now, the remaining counts are all felonies of the 5th degree. Felony of the 5th degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. So 6, 7, 8, 9, 10, 11, or 12. I'd select one of those numbers for each particular count, and that'd be the number of months in prison you have to serve on that count. You understand that?
Yes, sir.
Now, in this particular case, well, in any case, quite frankly, when there's multiple counts, if I impose a prison sentence, I can run, as the judge, I can run those prison terms either concurrent or consecutive to each other. Concurrent means you serve them together at the same time. Consecutive means one after the other. You understand the difference there?
Yes, sir.
So I need to make sure you understand what the maximum possible sentence imposed here. If I were to impose the maximum sentence on each count, which I told you was 8 to 12 years on count one, and then 12 months on each of the remaining felonies of the 5th degree, if I did that and ran them all consecutive, you're looking at a maximum possible prison term of a minimum, indefinite prison term of a minimum of 34 years up to a maximum of 38 years. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole to anywhere?
No, sir.
You're currently serving a prison sentence, though, out of the state of Florida, correct?
Yes, sir.
Now, as the judge, I have the discretion, if I impose a prison sentence in this case, to run that prison term concurrent or consecutive to the sentence you're currently serving out of Florida. You understand that?
Yes, sir.
So if I ran a concurrent, you'd start serving it immediately, and it would overlap, and you'd serve them at the same time. If I ran a consecutive, you'd finish the Florida, begin serving the sentence that I impose in this case. You understand the difference there?
Yes, sir.
Any questions about that?
No, sir.
Now, in regards to count one, the RICO charge, I explained how it's an indefinite prison sentence, and there's a minimum and a maximum. I need to advise you that there is a presumption that once you serve the minimum portion for that count, that you be released at that point. If there's any time for other counts before that, you'd have to serve that first. But then when you get to that count, whatever that minimum is, there's a presumption you'd be released at that point. That's not guaranteed, however. The prison officials, if you were to, when you are in prison, misbehave, violate prison rules, if you pose a threat to the community still, or you weren't sufficiently rehabilitated, they could have a hearing. I'm not a part of this at all, but they could schedule a hearing which you would be a part of. Establish that you did violate rules, you misbehaved when you were there, that you're not rehabilitated. they don't have to release you at that point. They can keep you. They would then pick a new date that becomes your new release date, and there'd be a presumption that you were released on that date, unless, again, you continue to misbehave, violate rules, be a threat. They can, again, delay it. Under no circumstances, however, can they keep you in beyond the maximum sentence. So even if, hypothetically, if you were there and just misbehaved the whole time you were there, they still have to release you after you've served the maximum sentence. You understand that?
Yes, sir.
You also do have the ability, when you're serving this portion of the count 1, the indefinite sentence, to earn good time credit while you are in prison. There's a presumption that if you did earn it, there's a presumption that you would get it. Ultimately, it would have to be approved by the court. Do you understand that?
Yes, sir.
All right. Now, upon your release from prison, you would be placed on what is called post-release control. It's sometimes referred to as parole, or PRC. It's a period of supervision you would be on after you completed the prison sentence. In this case, it would be for at least 18 months, but it could be up to 3 years. It's up to the parole officials to decide that. I don't have any on that.
Yes, sir.
And when you're on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison sentence is imposed by the court. Do you understand that?
Yes, sir.
All right. Now, aside from the possible prison sentences I just explained to you, there's other sanctions that can be imposed. You could be fined. Count 1 carries with it a possible fine of up to $15,000. All the remaining counts, the other 26 remaining counts, carry with it a possible fine of up to $2,500. So altogether, there's a possible maximum fine of $80,000 that could be imposed. You understand that?
Yes, sir.
In order to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
Also, you could be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not technically mandatory with these charges. You are eligible for probation, what's called community control sanctions. Now, in order to be eligible for community control sanctions, a pre-sentence report has to be completed. And you're waiving the preparation of a pre-sentence report and entering into a joint recommendation. So even though these are technically probationable, I will not be able to consider that because there's no pre-sentence report. Do you understand that?
Yes, sir.
And in addition, the count 1 carries with it a presumption for prison. That means I would have to impose a prison sentence unless I can make certain findings that would overcome that presumption and permit me to put you on probation. But that's not even a possibility without a pre-sentence report. Do you understand that?
Yes, sir.
All right. Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend the sentence to the court. The prosecutor is also allowed to recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty here?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you been able to review everything here with your lawyer and go over this with him?
Yes, sir.
Has he made any promises to you about what is going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
I know the prosecutors you've entered into a joint recommendation. They have to live up to that, but nobody's promised you that that's what I'm going to do for sure, have they?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering a guilty plea freely and voluntarily?
Yes, sir.
All right then, Mr. Santos, do you have any questions for me at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to?
No, sir.
Do you need any more time to speak with Mr. Weatherly before we go forward with your actual plea? All right, then what's going to happen at this time, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. You're going to group the receivings together, I'm assuming, correct?
Sorry, Your
You're going to
Honor.
group the receivings together.
Yes, Your Honor.
I want you to listen to her because I have some questions for you, all right?
Yes, sir.
All right, Ms. Gold?
Thank you, Your Honor. The facts would show that on December 20th, 2023, the defendant, co-defendant, and accomplices went to the YMCA in Willoughby, Lake County, Ohio. There, they used a window punch tool to break into Isabel Wright's vehicle and steal 3 of her credit cards. After leaving the YMCA, the GMC Terrain that the defendant and his accomplices were in drove through a red light on Euclid Avenue in Willoughby, Lake County, Ohio. This caused a multiple car collision and the GMC Terrain flipped over. The defendant and the other individuals in the car fled from the vehicle. The vehicle was then searched by police officers who located checks belonging to Tara Brigham, Laura Umek, Mark Steele, and Daryl Margadana, Rebecca and Todd Stacker, Michael and Sylvia Hostel, Cassandra Bishop, Lee Hua Su, Judith Fancelli, and Gabrielle Pickler. Officers located credit cards belonging to Isabel Wright, Christine Marie Fondren, Ruby Sue Higgins, Kellen Schuenenberg, Riley Rhodes, Pamela Stevens, John Mock, Rosemary Nichols, Sophie Kochek, Allison Berea, Jessica Miller, Daniel Stern, Jacqueline Palillo, and Francesca Rogers. Each of the checks is a negotiable instrument under Revised Code Section 2913.71, and each credit card is a credit card under Revised Code Section 2913.71. The defendant received this property as part of his association in an enterprise through a pattern of corrupt activity and had reasonable cause to believe that each item had been obtained through the commission of a theft offense.
Thank you. Mr. Santos, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show in this case if we did have a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then. Regarding count 1, charging you with engaging in a pattern of corrupt activity, a felony of the 2nd degree, what is your plea to that count?
Guilty.
Regarding count 2, charging you with theft, a felony of the 5th degree, what is your plea to that count?
Guilty.
Regarding count 4, 6 through 27, and 29, each charging you with the offense of receiving stolen property, each felonies of the 5th degree, what is your plea to each of those counts?
Guilty.
And lastly, regarding count 30, charging with possessing criminal tools, a felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand what this document says and that you've signed it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, sir.
Mr. Weatherly, is that accurate? Did you review this document with Mr. Santos, read it over with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did, Your Honor.
Is that correct, Mr. Santos?
Yes, sir.
So you did go over this document?
Yes, sir.
You understand what it says?
Yes, sir.
Do you have any questions for me about it, any part of it?
No, sir.
It also appears that you signed it a couple times on the page 5 and on the last page, page 8. Did you in fact sign the document?
Yes, sir.
Mr. Weatherly, you witnessed those signatures?
I did, Your Honor.
And you too, Ms. Gold?
Yes, Your Honor.
Very well, then. This time the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea and find the defendant guilty of count 1, engaging in a pattern of corrupt activity, a felony of the 2nd degree in violation of 2923.32A1. Count 2, theft, a felony of the 5th degree in violation of 2913.02A1. Counts 4, 6 through 27, and 29, each charging the offense of receiving stolen property, each felony is of the 5th degree in violation of 2913.51. And lastly, count 30, possession of criminal tools, a felony of the 5th degree in violation of 2923.24 of the revised code. The remaining 3 counts will get dismissed. Mr. Weatherly, you guys, your client is waiving the preparation of a pre-sentence report.
We are, Your Honor.
That's what you want to do, Mr. Santos?
Yes, sir.
All right, then, is there any reason not to go forward with sentencing? I do, for the record, have victim impact statements from co-defendants' cases, so I have those already. Mr. Weatherly, any reason not to go forward with sentencing then?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Judge, just briefly, a couple of points. I think perspective is important here. You know, one thing that my client struggled to understand in this case was how it is that you end up with these RICO charges, these conspiracy charges. From his perspective, and this was before I started representing him, because I know that I took time to explain this to him. He's thinking, well, yeah, I engaged in a bunch of petty, stupid crimes. These were low-level felonies. I didn't kill anybody. I didn't hurt anyone physically. It's not a sex crime. It's not a drug crime. How is it, you know, how does it result in this extremely serious felony of the second degree? And it took some time for him to understand that. But I was able to explain it to him, and he was able to understand it. And I don't think, regardless of what his relationship with his prior attorneys, that he understood it previously. Now, I think the world of Mike Goldberg. I think he's an outstanding attorney, does a great job for his clients. And I'm sure that he might say that about me in certain respects. And I know that I've had clients where they walked away and nothing that I said to them, it just went in one ear and out the other. I just could not communicate effectively, for whatever reason, with those individuals. And I think that that's not necessarily my fault or my client's fault. We just didn't have a good enough connection. I think the same could have been true with Mr. Goldberg and my client, in that despite his best efforts, he was unable to really articulate these things in a way that Mr. Santos could understand it. I think it goes, that probably holds true with the evidence as well. He needed to look at the evidence in that light, in the light of what is a conspiracy, what are these penalties, how serious are these crimes. Since he's been given an opportunity to do that with my counsel, I think he's come to the realization that these are very, very serious offenses. And that he also realizes that when the state is making him an offer for an agreed recommended sentence that they are, that he's actually benefiting greatly from it. And that he needs to take that benefit and appreciate it. And I think that that's the position that he's in front of you today, Judge. I think the other perspective that has been brought to his attention recently is that it's time for him to grow up, stop running, stop doing these stupid things, stop committing crimes, and start taking responsibility. He's in his 30s now. Maybe you can make an argument that when you're in your 20s you can be doing these stupid things, but not in your 30s. And most importantly, Judge, not when you have kids, because your kids rely on you. My client has 5 children, and they're all extremely young. And what he's imparted to me is, all I want to do is do my time, do it the right way, get out as early as I can, and then go take care of those kids. Because it's not those kids' fault that I'm in jail, it's my fault. When I heard that, I knew that we were ready to come here and take responsibility, and I think that's what you're going to hear from my client today, Judge.
Thank you. Well, Mr. Santos, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, sir.
Good.
Good morning, good afternoon, Your Honor. Today I want to just take accountability. Like, I really want to be there in my kids' life. I want to change, I want better. Since I've been incarcerated, like, I've tried to do so much that, like, on my own, that it ain't work, you know. So I got closer to God, and He been working for me. Like, seeing my kids, I have 5 kids. My oldest child is 3. I just want to be there for my kids. Like, bad. Like, I didn't really understand a lot of things in this situation. And I was confused, but I know what's going on now, so I just want to be there for my kids. I ain't had my dad growing up. I really did. And I want to be there for mine. So I pray that, like, y'all give me a chance to be there for my kids. Please. I'm begging y'all, please. Like, please.
Anything else you'd like to say? You don't have to, I just want to make sure you said everything that you wanted to say.
Yeah, yeah. I'm sorry for everything like that happened. I'm sorry, you know, whatever I gotta do to like institution or whatever the court like want me to comply with, I'm willing. I'll do whatever just to be back in my kids' life and do the right thing.
Okay.
And I would really appreciate it.
Mr. Weatherly, anything else on behalf of?
Just, Judge, that I think that what my client is asking for is for this honorable court to adopt the agreed recommended sentence as both the state and myself, and so I would echo that, Judge.
So you're joining in on that recommendation?
I absolutely am, Your Honor. Thank you.
All right. Ms. Gold, on behalf of the state of Ohio.
Thank you, Your Honor. On December 20th, 2023, the defendant woke up and he went to work. Not work with a company or with legitimate self-employment. The defendant went to work with his illegal enterprise, finding nearby gyms, fitness centers, and metro parks, places where patrons are more likely to leave their wallets in their car, places that make them ripe for the defendant and his associates to break into cars, steal checks, credit cards, and driver's licenses so that they can either themselves or find others to purport to be the individuals in the driver's licenses, and then go to banks to try to cash checks in other victims' names or make withdrawals from accounts in other victims' names. These actions are deliberate, these actions are thought out, and these actions are planned. In preparing for trial, my co-counsel and myself had the opportunity to speak with all of the victims in this case, and something we heard from almost every single person is how being a victim of this type of theft stole from them the feeling of safety in some sense. When the defendant and his cohorts broke into these vehicles, they stole driver's license with victims' home addresses on them, and in some cases, keys. These people were concerned that the defendant would know where they live. They don't know who has stolen their driver's licenses, their car keys, knows their home addresses, and this harm goes beyond the defendant's actions of simply breaking a window. The state would ask for restitution in the amounts written in victim impact statements for a total of $5,125.95, and would ask that this court adopt the state and defendant's joint recommendation for 6 years with time concurrent for the case the defendant is currently serving in Florida with 30 days of credit.
And that was part of the joint recommendation that the sentence be concurrent with this current sentence, correct?
Yes, Your Honor.
And my understanding is that his current sentence, his release date is October 27th of 27, maybe October 24th, October of 27, right?
Yes, Judge.
This court has reviewed the facts and circumstances of the offense involved. Well, we didn't do a pre-sentence report in this case. There was a co-defendant that I handled, and there was a pre-sentence report in that case, which summarized the police report, which I had previously had. I have considered what's been said here in court by Mr. Santos, the defendant, prosecutor. I've considered the joint recommendation. I've received several letters on behalf of the defendant as well as from the defendant, and I've read and considered all those previously. I received the victim impact statements in this case, again, with the co-defendant, but it's the same victims and same offenses, and I've had the chance to look those over. All this is considered in light of the purposes and principles of felony sentencing set forth in 29 and 2911. So the factors in 29 and 2912, excuse me, court finds that the defendant acted as a part of organized criminal activity. Nothing makes it less serious. As for recidivism factors, court notes the defendant does have prior criminal conviction. He's serving a prison term out of Florida right now. He did violate his bond in failing to appear, absconding from the state and leaving, being gone. Nothing indicates recidivism is less likely. In terms of the more serious, the court also just notes the nature of the conduct. The defendant has no contacts or ties to the state of Ohio. Him and his co-defendants are from Florida, or at least he's from Florida, but they came up here specifically for the intention of committing these offenses. Not just necessarily in Ohio, but on the driving up here up the East Coast. But they came here for the sole purpose of committing these offenses. That makes it more serious. There's a presumption for prison. It's also a joint recommendation for prison. Prison is consistent with the purposes and principles of sentencing. The presumption is not overcome. The defendant's not amenable to available community control sanctions. Therefore, it will be the sentence of this court, bless you, that on count 1, the defendant serve an indefinite prison term of a minimum of 6 years, maximum of 9 years. On count 2, 4, 6 through 27, 29, and 30, the sentence of the court, defendant serve a term in prison of 6 months on each of those counts. Counts 2, 4, 6 through 27, 29, and 30 will be served concurrent with each other, but consecutive to the sentence in count 1 of 6 to 9 years for an aggregate prison term of an indefinite prison term of a minimum of 6 years and 6 months to a maximum of 9 years and 6 months. He has credit for 30 days on this case. I will run this prison term concurrent to the sentence he's currently serving in the state of Florida. I need to advise you upon your release, you will be placed on post-release control for at least 18 months, could be up to 3 years. While on post-release control, if you violate any of the conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time, and it's ordered to pay all costs incurred in this action. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I'll dismiss the other 3 counts of the indictment. That would be what counts 3, 5, and 28 are dismissed. I'm going to order restitution in this case to Isabel Wright in the amount of $50, to Rebecca Stocker in the amount of $323.86, to Lee Hua To, it's H-U-A, and last name is T-S-O-U, in the amount of $760, to Deborah Diadiun, D-I-A-D-I-U-N, in the amount of $23, to Stephanie Bowles in the amount of $411.09, to Pamela Stevens, that's P-H, in the amount of $2,095, to Jacqueline Paolillo, P-A-O-L-I-L-L-O, in the amount of $1,463, court also finds that consecutive service is necessary in this case to protect the public from future crime and to punish the offender. It's not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that at least 2 of the multiple offenses were committed as a part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as a part of the course of conduct adequately reflects the seriousness of its conduct. Lastly, I need to advise you that the indefinite sentence that I just imposed, as I explained earlier, there's a rebuttable presumption that you will be released after you've served the minimum of that sentence in count 1. That presumption, however, is rebuttable. It's not guaranteed, which means that the Department of Rehabilitation and Correction can rebut the presumption if at a hearing they are able to establish that while you are in prison, you misbehaved, you violated the institution's rules, you're not sufficiently rehabilitated, you remain a threat to the society. If any of that were to occur, they don't have to release you at the minimum. They can continue your incarceration. They would select a new date for you to be released, and there'd be a presumption that you'd be released on that new date. However, again, they could establish at another hearing, if any of these factors still exist, they don't have to release you. Under no circumstances, however, can you be kept in past the maximum sentence for that count of 9 years. You also will have the right, as I indicated, to earn good time credit on that sentence in count 1. There's a presumption that if you earn it, that you would get it, though it has to be approved by the court. I think that covers everything. Ms. Gold, is there anything else for the record?
No, you're
In the matter of State of Ohio versus Shane O'Neill Sr., case number 26CR000104, the defendant is present in court with defense counsel Spiros Ganakis. We are here for purposes of a change of plea hearing. On April 13th of 2026, a 3-count indictment was filed against the defendant, count 1 being possession of cocaine, a felony of the 5th degree in violation of revised code section 2925.11a with an attached forfeiture specification. Count 2 being operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, an unclassified misdemeanor in violation of revised code section 4511.19a1h, and count 3 being operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree in violation of revised code section 4511.19a1a. All discovery has been provided at this point, Your Honor. Prior to entering into the plea, the state would move to amend count 3 of the indictment to include the language and facts of the priors that are contained in count 2, which would then make count 3 the unclassified misdemeanor. I have spoken to defense about this, and I believe defense
What do you
is
mean
in
it would
agreement
make it
with
the
this.
unclassified misdemeanor?
It is no longer a misdemeanor of the 1st degree. It's an unclassified misdemeanor with the priors. With the 2 priors.
Okay. No objection to that, Mr. Ganakis?
No objection whatsoever, Judge.
It's still less, this penalty is less than what count 2 is, correct?
Yes.
Your Honor, the only difference is those minimum mandatories.
Go ahead, Ms. Ronick.
Okay, so the state.
Well, I'll grant that motion then.
Thank you, Your Honor. And then with that motion being granted, it's the state's understanding that the defendant wishes to withdraw his previously entered plea of not guilty and enter a plea of guilty to count 1, possession of cocaine, a felony of the 5th degree in violation of revised code section 2925.11a with the attached forfeiture specification, and count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, the amended count 3 in violation of revised code section 4511.19a1a, an unclassified misdemeanor. There is no agreement as to sentencing at this time. Thank you.
Thank you. Mr. Ganakis, does that sound accurate?
That does, Your Honor. Yes.
Mr. O'Neill, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to 2 of the charges in this indictment. We'll count 1 and then amended count 3.
Yes, I do intend to change my plea.
Count 2 would get dismissed. We would then defer sentencing, get some evaluations completed, come back on a future day. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I ask you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
You guys set?
Yes, Judge. Yep. Thank you.
All right, well, let's get started then. How old are you, sir?
I am 46 years old.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescription drugs, prescribed medication, nothing?
No, sir, I stopped based on advice from my lawyer.
Now, you would have been served with a copy of this indictment, looks like about a couple months ago, end of April. Do you remember getting that
Yes, sir.
document? You had a chance to look that over at some point?
Yes, sir.
Now, in that indictment, you are charged with 3 counts. You're pleading guilty to 2 charges, so I'm going to review those with you. Count 1, what you're pleading guilty to alleges on or about January 17th, 2026 in Willowick Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance which contains cocaine. The amount did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it for me?
No, sir.
Now, the other count you're pleading guilty to is count 3 that's been amended. And what's alleged here and what you'll be admitting to is on or about January 17th, 2026 in Willowick Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's further alleged that you have previously been convicted or pled guilty to 2 or more violations of operating a vehicle under the influence of alcohol within the last 10 years. One of those violations being in the Willoughby Municipal Court on February 14, 2019. The other being in the Paynesville Municipal Court on January 17, 2023. That conduct with the priors constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. It's considered an unclassified misdemeanor. Do you understand what you're charged with and pleading guilty to an amended count 3?
I do, sir.
Any questions for me about that?
No, sir.
Now, there is another count, that's count 2. That would be dismissed pursuant to the agreement.
Yes, sir.
Now, let me go back to count 1 real quick. I just did omit something real quick. There's also a forfeiture specification that's a part of that, which alleges during the offense you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, like drugs. Mm-hmm. An instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to help facilitate a crime, and you can't use or possess it for that purpose. And here it's alleged that there's the drugs and the packaging. The whole point of this is that you lose your ownership interest in that, and it allows the state to dispose of it in the right way after the case is over. It doesn't increase any potential penalty you face. Do you understand that?
Can I ask him a question real quick? So
Sure.
So you're saying that I forfeit my cocaine?
That's the forfeiture spec. Yeah.
It's silly.
I'm sorry.
Yes. Yes.
That's why I was confused, sir.
What it does, it allows them to dispose of it properly. So there's
Yes, sir.
property sometimes that gets seized that people have ownership interest in, like a cell phone. Maybe that wouldn't it'd be something different, or money, or a car.
I understand.
Drugs is not really, nobody wants them back. If we give it back to you, we'll arrest you again for possessing it. But we have to have that. So it doesn't increase any possible penalty.
Yes, sir.
You understand that?
Yes, sir.
All right. Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up. And you first of all have a right to a trial. The trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means that all 12 of them would have to agree together, one way or the other, as each charge, whether you're guilty or not guilty. Do you understand that?
Yes, I do, sir.
You understand by pleading guilty or giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial, you have the right to have an attorney represent you at the trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. By having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You are presumed innocent of all the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since it's a criminal case, the burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of all that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least try to do that, if we had a trial, the prosecutor would be bringing witnesses into the courtroom to testify for the state, and they'd be answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He'd be permitted to ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
I do, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
I do, sir.
Do you realize you're giving up that right?
Yes, I do, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
I do, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but most importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, I do, sir.
You further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
I do, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
I do, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand your guilty plea will be a complete admission of guilt? That means you're going to be admitting to the facts being alleged by the state of Ohio. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
I do understand that, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future date, be sentenced by the court. Do you understand that?
I do, sir.
Now, as far as sentencing goes, you're pleading guilty in count 1 to a felony of the 5th degree.
Yes, sir.
This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
I do, sir.
Now, amended count 3 is what they call an unclassified misdemeanor. This offense is punishable by a mandatory term of local incarceration of at least 30 days, and you could be sentenced to up to 1 year of local incarceration, which means Lake County Jail. You understand that?
Yes, I do, sir.
Now, if the court imposed a prison sentence on count 1, any period of local incarceration imposed on count 3 would by law have to be served concurrent with the prison term. Concurrent means together at the same time. As the judge, I do not have the discretion to run a jail sentence on a misdemeanor consecutive to a prison term. Consecutive means one after the other.
I understand, sir.
So if prison's imposed on count 1, the jail sentence will automatically be concurrent to that. You understand that?
Yes, I do, sir.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, sir.
Do you have any other charges pending against you anywhere?
I do not, sir.
If a prison sentence is imposed on count 1, upon your release from prison, you could be placed in what we refer to as post-release control. It's sometimes called parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it's not mandatory, but it could be up to 2 years. You understand that?
Yes, sir.
And if you were on post-release control and never violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
I do, sir.
All right. Now, aside from the possible prison sentence I just mentioned, there's other sanctions that can be ordered. In terms of count 1, there's a possible fine of up to $2,500. On amended count 3, there's a mandatory fine of at least $1,040 that will have to be imposed, and you could be fined up to $2,750. Do you understand that?
I do, sir.
So at the time of sentencing, then a fine of at least $1,040 will be imposed, and you could be fined up to $5,250. Do you understand that?
I'm sorry, I don't understand that.
right.
What was the third thing I could be fined for?
No, I was telling you what the maximum was together.
They add the maximum plus
Now I
20.
understand.
So you'll be
sir.
fined at least $1,040.
Yes.
I was combining them just because I want to make sure you understand what the
Now I
maximum
understand,
sentence
sir.
you
Yes,
face is.
yes, sir.
Okay. Also, count 1 carries with it a possible license suspension. Well, actually, it's mandatory, isn't it?
108 days.
Count 1, it's if you do it, if you have a possession charge with an OVI, the suspension is mandatory.
I apologize, Your Honor. I did not realize that.
So count 1 carries a mandatory suspension of up to 5 years. It could be 1 day, it could be put up to 5 years, but a suspension has to be imposed on count 1. Count 2, the amended count 2 carries with it a mandatory license suspension of at least 2 years up to 12 years. You understand that?
I do, sir.
I could also order that you pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
I do, sir.
And also, you're going to forfeit the contraband that I mentioned earlier, the cocaine and
I
packaging.
understand,
You understand that?
It's all yours.
Now, a few moments ago, I explained the possible prison sentence for count 1. I used the word possible because prison is not mandatory. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
I do, sir.
Do you understand that just because you're eligible doesn't mean you'll be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. Then I'll make the decision I believe is the right thing to do. Do you understand that?
I do, sir.
Now, if you are put on community control, it could be up to 5 years, and as a judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions can be in order for count 1 that you serve a term of up to 6 months in jail as a condition of community control. You understand that?
I do, sir.
Further, if you are on probation, you ever violate any of the rules or conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. It's not originally 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate or end your probation and send you to prison then. If I did it at that point, again, it could be 6 to 12 months, which could also be consecutive to any other prison term you could be serving for something new, or that you're being sentenced to if you committed some new offense at that time. You understand that?
I do, sir.
Lastly, when we do proceed to sentencing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf, recommend a sentence to court. The prosecutor can also recommend a sentence to court. Do you understand that?
I do, sir.
Do you understand that whatever anyone says at the time of sentencing, including the lawyers, regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to go along and follow that if I didn't think that was the right thing to do.
I do understand that.
All right, well, do you have any questions at all then regarding the potential penalties you face by pleading guilty?
Not today, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
I do, sir.
Do you have enough time to talk about this case with your lawyer and have him go over the reports with you, discuss the issues, and answer whatever questions you may have?
I have, sir.
Are you satisfied with the advice and counsel of your lawyer?
I am, sir.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
I have not, sir.
Are you entering your guilty plea freely and voluntarily?
I am, sir.
All right, then. Any questions for me at this time regarding anything we've talked about, the rights you're giving up, penalties you face, what you're pleading guilty to, the amendments, anything?
No, sir, I have no questions.
Do you need any further time to speak with Mr. Ganakis before we go forward with your plea?
No, sir.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial. If we had a trial, I want you to listen to her because I'll have some questions for you about that, all right? Ms. Ronick?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on January 17, 2026, in Willowick, Lake County, Ohio, the defendant did knowingly possess cocaine, a Schedule II controlled substance, and on that same date, in the same location, the defendant did operate a vehicle while under the influence of alcohol, drug of abuse, or a combination of them, and that additionally, the defendant had been previously convicted of 2 or more violations of the OVI statute, specifically in case number 18 TRC 07090 in the Willoughby Municipal Court dated February 14, 2019, and in case number TRC 2300137A in the Painesville Municipal Court dated January 17th of 2023. Specifically, Your Honor, the state would have proven that on January 17th of 2026, the defendant was subject to a traffic stop in the city of Willowick. The defendant exhibited signs of impairment, did admit to having 3 beers. He had trouble balancing while walking. He did refuse field sobriety tests, but consented to a breath test at the police department and blew a 0.193. An inventory search of the defendant's vehicle located a small Ziploc bag with a white substance in the front driver's door pocket. That substance was sent to the Lake County Crime Lab and was found to be 0.25 grams of cocaine, a Schedule II controlled substance. Thank you.
Thank you. All right, Mr. O'Neill, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, did you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir. I admitted it at the scene. I'll admit it now. I am guilty of the DUI, yes, sir.
I'm sorry?
I said I was drinking and driving, sir. I said I'm guilty.
And did you knowingly possess cocaine?
I knew it was in the vehicle, yes, sir.
Very well. Regarding count 1, charging you with possession of cocaine, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty, sir.
And regarding amended count 3, charging you with operating a vehicle under the influence of alcohol, or drug abuse, or a combination of them, a unclassified misdemeanor, what is your plea to that?
Guilty, sir.
All right, I have in my possession here at this time a 4-page document called a written plea of guilty and judgment entry, which explains and sets forth everything we just talked about.
Yes, sir.
Before I can accept your plea, I need to make sure you understand this document, that you've signed it here in open court. And my understanding is before I walked out here, you had a chance to go over this with Mr. Ganakis. Is that
Yes,
correct?
sir, I did.
Mr. Ganakis, is that correct? Did you read this over to your client, review it with him, answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you?
He did, Your Honor. Yes.
Is that correct, sir?
Yes, sir.
And so you understand what the document says?
I do, sir.
Any questions for me about it?
No, sir.
It also appears you signed the document. Did you sign it?
Yes, sir.
And you witnessed that, Mr. Ganakis?
I did, Your Honor.
And you too, Ms. Horonic?
Yes, Your Honor.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding that to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree in violation of 292511 of the revised code with the forfeiture specification, and amended count 3. Well, the first one was count 1. I don't know if I said count 3. Amended count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, unclassified misdemeanor, violation of 4511.19A1A. Count 2 will get dismissed at sentencing. I'll defer sentencing, order pre-sentence report and investigation, drug and alcohol evaluation, and I will continue bond at $10,000. Cash surety or 10% with conditions that the defendant be on scram monitoring, no drinking alcohol, no drugs, no driving a vehicle. So what that all means, as far as bond goes, I'm continuing to bond. Nothing's changed. You need to comply with the conditions. Again, one of the conditions is that you don't use any drugs or alcohol. You have to submit urine screens if requested. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued. Do you understand that?
Yes, I do, sir.
The purpose of this report, so I can learn more about you before sentencing. And the way the probation department gets the information they need to generate the report is they're going to conduct an interview with you. It's important that when you meet with them that you're open and honest with them, because they're going to check and verify everything you're telling them. And if they learn you're misleading them in any way, whether it's flat out lying or even not that bad, but exaggerating or minimizing something, they're going to let me know that. And I would consider that obviously at sentencing. You understand that?
Yes, sir.
All right, so you're going to leave here now. You're going to go to the probation department right from here. You know where that is, right?
Yes.
You'll show them where that is.
I'll walk him there, Your Honor.
Okay. And you're just going to fill out some initial paperwork and get your dates to come back there for your interview. So make sure you go there right when you leave here. And then
I
make
will,
sure you
sir.
show up when you're supposed to for that interview. If they can't conduct the interview with you because you don't show up like you're supposed to, they can't do a report. Without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to another day to get the report done because it wasn't done timely initially because you didn't show up when you were supposed to. You understand that?
Yes, sir, I'll make sure I am.
You're right. Perfect. Anything else, Mr. Ganakis?
Judge, the only other thing I would add is Shane's been on the scram with no violations for 6 months. He's an 11-year vet from the Navy. He's a landscaper. Does have a medical marijuana card. So when he tests positive, he will test positive for marijuana. I wanted the court to know that. Your Honor, it has been, he is not under the...
He's not supposed to be using marijuana. It's been a condition of his bond this whole time. I don't know what to tell you.
Judge, I want the court to know, we've had conversations. The alternative is pain pills from the VA, and that's...
He's taking it into his own hands. I mean, there's a condition of bond that he not use any drugs, and there's a specific condition that he not use marijuana. Anything else?
No, Your Honor, thank you.
All rise.
Thank you, Your Honor. We are present this afternoon in the matter of State of Ohio versus Shawinigan Clark. This is case number 25 CR 1598, present open court. This afternoon is the defendant with his attorney, Chad Malky. We were last here for a change of plea. At that time, the defendant pled guilty to count 1, felony 3, heavy weapons under disability with a forfeiture specification, balanced the indictment to be dismissed. Upon sentencing, this court ordered a pre-sentence report, which was completed, and the state is prepared to proceed with sentencing this time.
Thank you. Mr. Mulkey, anything you like, any reason not to go forward with sentencing?
No, Judge.
Anything you'd like to say on behalf of your client?
Thank you, Judge. Yes, he is 60 years old. He has a valid driver's license. He is gainfully employed, still working in the security field. Knows not to carry a firearm. If there was any question before, there is none now. He, I believe, regrets the facts and choices that brought him to the court here today. He does have some criminal history. We would nevertheless be asking this court for an order of community control. He is currently on probation out of the Willoughby Municipal Court for protection order violation. His 30 days of electronic monitoring and house arrest, 6 months of probation. He has 16 hours of community service to complete there through that court. He indicates to me he's been doing well on probation through that court. I've been able to get a hold of him and contact him whenever I've needed to. I'd submit that he would be an excellent candidate for community control, that he will follow the court's orders, he'll continue to work. He had negative screens. There's no drug or alcohol issues pertaining to the matter before this court. So other than that, Judge, we would defer to the court for sentencing. Thank you.
So when does the electronic monitoring house arrest end? If you know. Do you know when that ends?
Oh, yes. Should be the 11th of July. I currently have it on my leg here.
So it's been on about 2 weeks so far?
Yes, sir.
Do you pay for that, or is the court paying for that?
The court pays for I have to pay the initial fee, which I paid, which was $50. The court pays for that, which was, I think it's $250. The court pay for it.
Okay.
And they allow you, I just got to report it where I go. Like if I go to work, I'll just report it.
But you're allowed to go to work, but otherwise you have to be at home?
Yes, sir.
Okay.
I believe he has 2 days of credit, Judge.
How many?
2 days of credit.
All right, Mr. Clark, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say?
I just want to just say, Jan, I just want to just go forward with my life. I'm back on a straight and narrow path where I just want to just do right and just keep going. You know, I'm at the best where I can be right now. You know, just positive thinking, working. You know, and I'm just focused on life right now, and you know, that's where I'm at.
Okay. Thank you. Mr. Mulkey, anything else?
Your Honor, I do note that during the incident and the stop, it's indicated that he was honest with the officer about the gun and pretty much immediately brought that to the officer's attention. Nothing further, Your Honor. Thank you.
Thank you. Mr. Downing for the State of Ohio.
Thank you, Your Honor. As the state put on the record at the change of plea, pursuant to the terms of the negotiated plea in this case, the state is going to make a joint recommendation for community control. Did read the pre-sentence report. Nothing in there would invalidate that, so that is the recommendation of the state today.
Thanks. Cindy Cassidy? All right, this court has reviewed the pre-sentence report and investigation and considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today. All this is being considered only the purposes and principles of felony sentencing set forth in 292911. For the factors in 292912 that make the offense more serious, nothing stands out factually indicating it's more or less serious. As For recidivism factors, the court notes the defendant does have a history of criminal convictions. He has violated probation before in the past, so he has failed to comply in the past with previously imposed sanctions ordered by courts. Nothing indicates recidivism is less likely. Under 2913B1, the court notes the defendant did possess a firearm during the offense, that it overrides the presumption. However, court finds prison is not consistent with the purposes and principles of sentencing. The defendant is amenable to available community control sanctions. Therefore, I'm going to put the defendant on community control sanctions for a period of 1 year. As conditions, I'm going to order the defendant to serve 2 days in jail with 2 days of credit. I am going to order that you be put same electronic monitoring house arrest for an additional 30 days. So you're going to have to stay. You're going to have to stay on that longer. I'm not going to send you to jail, but I'm going to put you on house arrest for longer. That'll start on under this sentence. It'll start July 12th for 30 days. The county will pay for that. You won't have to pay for that.
Not a problem, sir.
Further conditions, so that's house arrest. You can go to work, and you can go to whatever probation obligations you have. You have to go to probation or whatever appointments that you're required to do for probation, but that's it. Otherwise, you're on house arrest.
Not a problem, sir.
All right. Further conditions, you're not to use any drugs or alcohol. Must submit random urine screens. They have to be negative. I want you to successfully complete the decision points program, follow all their recommendations. Probation will review that with you. To maintain a full-time employment, pay court costs and supervision fees. I'll order the forfeiture of firearm and any other contraband that was set forth in the specification. Counts 2 and 3 will be dismissed. Bond will be released. Ms. Henley, is there anything else I should be considering?
Your Honor, I'm just wondering if by chance Mr. Clark has the date wrong,
Oh,
do you
all
want
right.
to just state?
That's a good point. I want you to do 30 additional days from the day that your house arrest ends with, is it Willoughby or is that a Willoughby?
Yeah.
At a Willoughby. So if you have the date wrong by a day or two, whatever, you're going to do 30 additional days starting from the day after that ends.
Yes, sir.
All right. So you understand all the conditions of your community control?
I do, sir.
Any questions for me?
None.
Well, another specific condition I want listed, I shouldn't have to say, but you're not to possess or own any firearms.
I don't have a problem with that at all.
Well, if you do, you're going to be charged with another felony. But
Yeah, I have no problem
it's a
with that.
special condition, so that if you don't get charged, if you get caught with a gun or seen with a gun, but they don't charge you, you're still in violation of your probation. You don't have to
Yes,
be
sir.
convicted of a new offense. You'd be in violation. You understand that?
Yes, sir.
All right. If you violate any of the conditions of your probation, leave Ohio without permission from the court, commit another crime while on probation, a motion to terminate your community control will be filed. If it's found that you violated, I could extend your probation up to 5 years, I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 36 months in prison, so that's what's hanging over your head. You understand that?
I do, sir.
All right. All right, Mr. Downing, anything else for the record?
So what I'll do for the entry is just put the 30 additional days of EMHAs to begin on the day after Willoughby Municipal Court case, and I'll put the case number in there. Do you want me to, you'd also mentioned conditions for when he's allowed to leave. Do you want me to specifically note those in the entry? Or
Yeah, say that he's allowed to, he's given privileges to be released for work and for probation obligation, probation and court obligation.
Medical, Your Honor?
Is there medical issues?
He does.
All right, well then
Cardiac
for doctor's appointments as well.
Yes, sir. Thank you.
And you'd also mentioned that the county to pay, does that need to go in the entry as well or no?
Yeah, we probably do put that. Don't we put that pursuant to the, what's the name of that?
Jail diversion.
Jail diversion. Use the word jail diversion. He's placed on jail diversion, house arrest through jail diversion.
Okay.
Or electronic monitoring arrest through jail diversion.
Okay, thank you, Your
Right?
Honor.
Thank you.
All rise.
President State of Ohio versus Richard Jones on case number 26 CR 179. We are here today for purposes of sentencing, and the defendant is in court represented by counsel Chad Mulkey. When we were last here, the defendant waived his right to indictment and pled guilty by way of information to count 1, gross sexual imposition, a felony of the 4th degree, and the court referred the defendant for a pre-sentence report, victim impact statement, and drug and alcohol evaluation. Those have been completed, and the state's prepared to proceed with sentencing.
Thank you. Mr. Mulkey, is there any reason we should not go forward with sentencing at this time?
No, Your Honor.
Before we proceed to sentencing, I'm going to address registration requirements that the defendant will be required to follow. As I advised you, Mr. Jones, at the time of the plea, you will be classified here at sentencing as a Tier 1 sex offender, and that's going to require you to register at certain times. And I'm going to go over all that with you right now. I'm going to read this to you. I'm required to read a form to you. I'm not expecting you to memorize it. You'll get a copy of this when it's all over. When I'm done reading it to you, I'm going to have you sign it. Your signature is simply acknowledging that I read it to you and that you understand it. So I'm going to do that at this time. Let me verify some information briefly. Your Social Security number is 302-929090?
Yes.
And middle name John?
Yes.
Your expected residence address is 8207 Denison Avenue in Cleveland?
Yes.
And I got a phone number of 501-7671?
Yes.
It's 216 area code?
Yeah.
All right, you have pled guilty to a sexually oriented offense, and you are hereby classified as a Tier 1 sex offender. As such, you will be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you are temporarily domiciled for more than 3 days. You're also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here in Ohio, you will be required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You're also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you will be required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or for an aggregate or total of 14 days in a calendar year. Employment does include volunteer services. Now, you will be required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of the initial registration, you will be required to periodically verify your residence address, your place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and/or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment or place of education at least 20 days prior to any change and no later than 3 days after you've changed any employment. If your residence address change is not to a fixed address, you will include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register that fixed address with the sheriff. You are further advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to you or used by you to the sheriff with whom you most recently registered. Now, since you are a Tier 1 offender, you will be required to comply with all of these requirements for a period of 15 years with in-person verification annually, which means once a year. Since your expected residence address, as I referenced above, is in Cuyahoga County, you will register in person within 3 days or 3 days after any release from incarceration, if there is incarceration, with the County Sheriff's Office, Cuyahoga County Sheriff's Office, located at 1215 West 3rd Street in Cleveland, Ohio. Now, your failure to register, your failure to verify residence at specified times, or your failure to provide notice of a change in your residence address or other required information, as I just explained to you, will result in additional criminal prosecution. So, Mr. Jones, do you understand all the requirements that I've just explained to you?
Yes, I do.
Do you have any questions for me? Again, you're going to get a copy of this form, but do you have any questions at this time?
I don't have any questions.
All right, I'm going to hand you this form now, and on line 11 it reads, I acknowledge that the above requirements have been explained to me and I must abide by all of them, which is the provisions of Ohio Revised Code, Chapter 2950, which is the section of the law where this is set forth. So I'm going to have you place your signature and date on line 11.
Today's date, 29th?
Today's the
Oh,
29th.
it's already printed in there.
Today's the 29th.
Yeah, the date's in there.
All right, I'm going to place my signature now on line 12, which reads, I certify that I specifically informed the offender of his duties set forth above, and he indicated to me an understanding of those duties. Mr. Shannon, if you can take this and make copies, at least, 1, 2, 3, 4 copies to disperse. All right, with that matter addressed, Mr. Mulkey, is there anything you would like to say on behalf of your client at this time?
Yes, Your Honor. Thank you, may it please the court, counsel, and others here today. He is 35 years old. I will note for the court that he has led a law-abiding life for a number of years, with this being his only criminal offense. He is gainfully employed at River Recycling in Cleveland. He's at a stable residence that he shares with a brother at 8207 Denison in Cleveland. It is noted that he does appear to have some issues with alcohol, Your Honor. So we'd be asking the court for a couple different things. Community control, certainly with no additional jail time, no prison time, that he be given a drug and alcohol counseling and follow any recommendations from that, and attend meetings for Alcoholics Anonymous, however meetings the court would see fit, that he attend those meetings, that he comply with any and all other recommendations. He did indicate, at least in his written version in his pre-sentence report, that he feels terrible about his actions. This is not a situation to be repeated. Again, it happened back in 2021. That certainly doesn't excuse it, just he hasn't had anything like this happen that's come to anyone's attention since then, nor does he plan to do so in the future, Judge. So all of that being said, we would just ask the court for the community control, no additional jail time, and substance counseling and AA meetings. Thank you.
Mr. Jones, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No, I do not.
Very well. Mr. Mulkey, anything else?
Not at all, Your Honor. Thank you.
Ms. Leshy for the state.
Thank you, Your Honor. The defendant pleaded guilty in this case to engaging in non-sexual contact with a 14-year-old victim. What is significant to the state here is the age disparity between the defendant and the victim at the time of the offense. The victim would have been between 14 and 15 years of age, and the defendant was approximately 30 years of age, which would have been more than 15 years her senior. The defendant's relationship with the victim also facilitated this offense. The victim regularly spent weekends at her aunt's house where the defendant was present, and it was this access that also facilitated this offense. Also significant is the defendant's conduct leading up to this offense. Prior to the sexual contact, the defendant had provided alcohol to the victim and drank with her, conduct that he engaged in routinely with her. This offense has had a lasting impact on the victim. It was not until years later, when she had received a text message from the defendant, which was sort of a tangible documentary proof that she then had, which removed the fear of not being believed, that she was finally able to come forward and reported the offense to law enforcement. Although the defendant claims not to remember this offense because he was intoxicated, the defendant in the pre-sentence report indicated he remembers telling the victim that he loved her, which is consistent also with the victim reported to the police and to the state of Ohio. And then conveniently, the defendant doesn't remember what happens next. When the victim responded to the defendant's text confronting him with what happened, his response was that he wasn't proud of it, referring to what he did, and he apologized to her, which I think indicates that he does remember what happened here. The state is recommending community control sanctions with local incarceration. We're recommending drug and alcohol treatment considering the facts that led to this offense and the fact that he was also diagnosed with alcohol use disorder. As of today, the defendant has no days of credit. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation, the victim impact statement that was received. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-2912, the court finds that the defendant's relationship with the victim facilitated the offense. These are factors indicating the conduct is more serious than normal. The relationship facilitated the offense. The victim has suffered serious psychological harm as a result of the conduct, and that's been exacerbated due to the age of her at the time of being only 14 years of age and the defendant being 30 years of age. There's a significant gap here, 16-year difference in the ages of the participants here, the defendant and the victim, when this happened. He also, other factors indicating more serious is that he bought alcohol for her and was drinking with her, 14 at the time when this occurred. Nothing indicates the conduct is less serious. As for recidivism factors, the court finds that the alcohol use related to this offense, and the defendant's been drinking ever since, and he drinks a decent amount, and he doesn't believe he's got any issues with that. But most importantly, there's no genuine remorse at all in regards to this offense. None. Factors indicating recidivism is less likely. The court finds that the defendant does not have any prior criminal history and led a law-abiding life for a significant number of years, basically his life, except for this one incident. Under 29-2913B1, the court notes that this is a sex offense that overrides the presumption for community control, permits the court to impose a prison term. The court at this time finds that prison would not be consistent with the purposes and principles of sentencing. The defendant is amenable to an available community control sanction. So I'm going to place the defendant on community control sanctions for a period of 2 years. There's going to be some consequences, though. The defendant's going to serve 75 days in jail. He has no credit. I want him to participate, enter, and successfully complete the jail treatment program during the last 30 days of his sentence. Follow all aftercare recommendations. Further conditions: you're not to use any drugs or alcohol. You must submit random urine screens. When requested, they have to be negative. Positive screens a violation. I'm going to order that you attend AA meetings pursuant to whatever JTP recommendations are. So they're going to give recommendations. If they say you don't need to do any AA meetings, then you don't have to do any. If they recommend 2, 3, or 5, you have to do whatever they recommend for AA meetings. And that'll be a condition of your probation. Further conditions: you're to obtain and maintain full-time employment. You're not to have any contact with the victim in this case in any manner, whether it's phone calls, text messages, emails. You can't have anyone else have contact with her. Pay court costs and supervision fees. I'm going to order also mental health evaluation. Follow whatever recommendations are made for any type of counseling or treatment. Derek, is there anything else I should be considering here?
Judge, I don't know if following through with all registration requirements.
Oh, yeah. You have to follow through, comply with all the registration requirements. Obviously, if you don't, that's a separate offense you can be prosecuted for, but it will also be a violation of your probation for at least the 2 years you're on probation. So, Mr. Jones, you understand all the conditions of your probation?
Yes, I do.
Any questions for me?
No, I do not have any.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, you leave Ohio without permission from the court, or if you commit another criminal offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, it could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including order that you serve time in jail, or I could terminate your probation and send you to prison. If I did that, it would be 18 months in prison, which would be consecutive to any other term you could be serving for something else that you're being sentenced to at that time. You understand that?
Yes, I do.
All right, Ms. Leslie, anything else for the record?
No, Your Honor, thank you.
Mr. Mulkey?
No, Your Honor, thank you.
today in the state of Ohio versus DeAndre McRae, case number 26CR596. The defendant is present with counsel Chad Mulkey. We're here today for a sentencing hearing. We were last before you on May 26th, and at that time, the defendant pled guilty to count 1, failure to comply, a felony of the 3rd degree. During that hearing, a pre-sentence report was ordered. That report has been completed, and the defendant has 68 days of jail time credit.
Thank you. Mr. Mulkey, any reason not to go forward with sentencing?
No, Judge.
Anything you'd like to say on behalf of your client?
Yes, Judge, thank you. He is 28 years old. He has 3 children. He did receive his GED. He would like to, when he gets out of jail or prison, pursue factory type work or work in a warehouse of some type. He does have a residence at 756 East 133rd Street in Cleveland. He lives there with his aunt and his cousin. In his PSR, and after my conversation with him, he understands, at least if it wasn't clear to this point, that running from law enforcement is never a good idea, and it exacerbates things. It makes them 10 times worse than they would be. He indicated that he would take care of his responsibilities in the future. Only time will tell. There's no way to predict whether he will, but he said that he will. He does have a record. He has been to DYS, and he has some adult criminal history as well. However, he would be asking for community control in this matter, follow any and all court orders for community control, and that he understands he's looking at a driver's license suspension. If the court does give him prison, we would just ask that the license suspension not exceed the prison term by too much more time. We understand that asking for a license suspension to be less than the time that the court would consider for prison wouldn't be any sort of a consequence, Judge. So we just ask the court to keep that in mind. But we are asking for community control with 68 days of credit. Thank you.
Mr. McRae, you have the right to address the court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
Yeah, I got something I wrote down.
Can you help him, Mr. Mulkey?
Oh, yeah, sure. I'm sorry. Yep. You want to read it, or do you?
Yeah, I'll read it.
Okay, all right. You got it? All right.
I'd like to say good afternoon. I would like to start by saying I take full responsibility for my actions, and I understand the seriousness of the charge. And I'm not speaking on my behalf to take away from the seriousness. I'm speaking to assure you that if I was granted another opportunity in the community, that I'll learn my lesson and understand what comes behind not complying with an officer. That day, I put many lives in jeopardy, innocent bystanders, the officer, and mine. But I'm glad no one was injured or no vehicles was damaged. Who's to say if there was a next time that I'll be lucky enough to be in front of a judge? Because not many police chases end well, or with everyone seeing their family again. That would make matters way worse than a failure to comply and possibly a vehicular homicide. Then the ones depending on me will really be let down and left to figure things out on their own. So I need to not just say I'm a man, but act as one. Because fleeing was not the righteous thing to do. That day could have changed and impacted everyone's life that was involved, even the ones that wasn't involved. I'm not asking to not be punished nor held accountable, but I'm asking if there's any way possible I can be home while being supervised. I promise you won't regret giving me another chance. Since being incarcerated, I missed plenty moments with my daughters, even though I try to video check them as much as possible. But that's not like being physically there. My son graduated 8th grade, and I would like to help him stay on the right path and not veer off like I did, which led me to catching a juvenile charge. I am very apologetic about the situation and have a clear understanding that it's not one bit of okay to not comply with the officer. That's all I got to say.
Thank you, sir. Mr. Mulkey, anything else?
No, Your Honor. Thank you.
Ms. Bell for the State of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and the state certainly does acknowledge that the defendant does not have a long criminal history. However, there are several troubling things
He has 2 cases from 2017. There are warrants out for both of those, and also a case from 2022 that has also a warrant out and a probation violation. The defendant also has a juvenile adjudication in which he was ultimately sentenced to DYS, which is certainly significant. And just the nature of the charge that we're here with before you today, a failure to comply, just shows an inherent disrespect and disregard for following the law. So the state does not believe that the defendant would be an appropriate candidate for community control and would ask for prison. Thank you.
Thank you. This court did review the pre-sentence report and investigation that was completed. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here today by the defendant, his lawyer, the prosecutor, the recommendations. I also received several letters in support of the defendant. I've read and considered all of those. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911. For the factors in 2912, which make it more serious, none of those factors are present. However, the court is also required to consider factors set forth in 2921.331B in this type of offense and determining whether the offense is more or less serious, and for more serious factors, I should say. And in this case, the court notes that the defendant was fleeing without any due regard for the safety of others, and he was at an excess of 105 miles an hour on the freeway in a 65-mile-an-hour zone. He was driving 105. The pursuit lasted over 9 miles. Before the defendant, quite frankly, was able to get away and this pursuit was terminated. Nothing makes it less serious. As for recidivism factors, the court finds the defendant has a history of juvenile delinquency adjudications as well as convictions as an adult. As a juvenile, he has a very serious offense in which he was ultimately committed to the Department of Youth Services. As an adult, there are 4 prior convictions. Misdemeanor convictions. Well, no, I'm sorry, 3 misdemeanor convictions. The problem I have is that there's warrants in every single case because you don't show up. You don't appear in court. Portage County, bench warrant issued. Portage County, another bench warrant issued. Cuyahoga County, there's a probation violation because you didn't appear for your probation, and there's a warrant issued for you there. So there are warrants issued also in 2 current traffic offenses that you got cited for 3 years ago. No. You're cited, I think, maybe it's 9 years ago, but there's warrants out for you this whole time because you just don't go to court. You don't face your responsibilities. I don't know how I'm supposed to find that you're going to be amenable to community control and report when you're supposed to when you've shown that you never do. You have failed to comply with previously imposed sanctions ordered by courts. As I alluded to, you're on probation when this offense happened, which is a factor indicating recidivism is more likely. And you're still on probation with a warrant issued for failing to report. No factors are present indicating recidivism is less likely. It's a felony of the 3rd degree. There's no presumptions one way or the other. Prison is certainly consistent with the purposes and principles of sentencing, and I don't know how I could find that you're amenable to community control sanctions when you have demonstrated you're not. You're not going to do what you're supposed to do. The whole nature of this offense is you fled from the police when you were being ordered to stop. And you don't go to court, you don't do anything you're supposed to do. I can't find you're amenable to community control sanctions. Therefore, it'll be the sentence of this court that on count 1, defendant served a term in prison of 12 months. He has credit for 68 days he's already served. Need to advise you upon your release, you'll be placed on post-release control. The court finds that this offense is an offense of violence and that it included, as the defendant even said, a risk of serious physical harm to 2 persons. Therefore, it's an offense of violence. Post-release control is mandatory for at least 1 year, up to possibly 3 years. You know, suspend your driver's license for 3 years. That starts today. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. The defendant is ordered to pay all costs. Is there anything else for the record, Ms. Bell?
Nothing further, Your Honor. Thank you.
Mr. Mulkey?
No, Your Honor, thank you.
All rise.